1L rep for Law Students for Life. Today we have two guests, but I'm proud to introduce Mr. Tom Fisher, who has been Indiana's first Solicitor General since 2005, and in that role as Solicitor General, he defends the state's laws against constitutional attack, advises the Attorney General of the state, and handles Indiana's United States Supreme Court docket. In that, he's also the two-time recipient of the National Association of Attorneys General Award for Best Brief, that is for Supreme Court brief writing. And he's also argued a number of cases before the court and before the United States Court of Appeals for the 7th Circuit, and of course before the Indiana Supreme Court on a number of issues, and defended many of the state's laws. Mr. Fisher also teaches law at Maurer School of Law of Indiana University.
Thank you, S.G. Fisher, for being here. I'm briefly going to introduce our other speaker, just a PSA. He's on the way from the airport, so stick around to hear remarks from S.G. Scott Stewart as well. And I'll briefly introduce him here just so he gets his finger shake too. He graduated from Princeton University and Stanford Law School. He served as a law clerk to Judge O'Scanlan of the U.S. Court of Appeals for the 9th Circuit and Justice Clarence Thomas of the Supreme Court. He has worked throughout his career in the OLC, in private practice as a litigator, and as Deputy Assistant Attorney General for the Civil Division of the Department of Justice. He was appointed in 2021 as Solicitor General for the state of Mississippi, and most recently and notably won and argued the case Dobbs in the last term. Thank you all for being here, and S.G. Fisher, thank you so much.
Sure. Thank you. Yeah, you're in for a real treat when Scott gets here. He and I have had a lot of fun working together over the years, not only on abortion-related litigation, but other matters too. I'm very interested to hear his reflections on Dobbs, as I'm sure you are too. And I'm going to leave that portion of the discussion for him. I don't want to steal any of his thunder. So you all have a sense of Dobbs, I'm sure. It's not a great mystery as to what it signifies. And I think what I want to talk about principally is what has happened in the wake of Dobbs in Indiana, and a little bit nationally, but how states are involved and engaged in legal challenges over abortion laws since then. So the first thing that you have to keep in mind is that in leading up to Dobbs, there were any number of state laws regulating abortion that were subject to challenges in federal courts that all ended up being enjoined under the sort of very loosey-goosey kind of impressionistic subjective standards that prevailed in the wake of the Hellerstedt case. And we had several of those in Indiana, and you had to sort of have a scorecard to keep track of which laws had been enjoined and which ones were being permitted to go forward. And in fact, we had just come off a trial in 2021, a two-stage trial that really were kind of a full array of our abortion laws were under attack under the Hellerstedt decision, which was effectively, sort of a cost benefit to the impediments to abortion. Are they greater than, or are they outweighed by the benefits to patient safety, et cetera, et cetera? And these were really very difficult cases because so much depended on the district judge's review of battles of experts and that sort of thing. So when Dobbs comes out, we are left with a number of cases in the pipeline, one of them at the U.S. Supreme Court waiting on Dobbs, others in the 7th Circuit, others in the district court that were perhaps at post-preliminary injunction but before summary judgment stage. So we had to put together a strategy, kind of assumed once the leak happened in Dobbs, we sort of had an assumption that, we need to act as if that's probably our best guide to what Dobbs is going to say. So we had a strategy in place, but we had to strategize about which cases do we go after first, how do we go after them to lift these injunctions, what if there is some crazy theory that the plaintiffs in these cases come up with to try to perpetuate the case itself, if not the injunction. And so a lot of careful thought went into that. And of course, when you are on the winning side of such a momentous decision, you want to sort of play it out and have the full array of impact as quickly as you can. And we found ourselves in a very odd position in one of our cases, in fact, in the one in the US Supreme Court, that had to do with parental involvement. And this was a case that I think we should have won on the pre-Dobbs law, and yet we were unable to get more than one judge to agree with us in the Seventh Circuit. But this was a case that it required notice to parents if there was a judicial bypass order permitting an unemancipated minor to have an abortion. Just, notice, not, and it didn't, all it had to do was be before the abortion. It didn't have to be a certain amount of hours, didn't have to facilitate the parents getting, sort of in the way. They just had to know about it. And this was too much even for some judges under Roe and Casey and Hellerstedt. So we wanted to get that injunction lifted as quickly as possible. We were aware, of course, that our legislature would, when given the opportunity, very likely enact a very broad ban on abortion. But who knows when that would happen? There was talk of a special legislative session that would happen in the wake of Dobbs, but we weren't sure if that would come to pass because, that's up to the governor. Would it be until January, February, March of this year before we had an abortion law? We didn't know. So we very quickly tried to go to the Supreme Court and say, okay, you're holding our case, you've just issued Dobbs, please will you expedite everything and just declare the injunction lifted. And they didn't want to, that was too much for them. No, they're gonna grant the petition and remand it and let it go through all the courts. So we're going to every court along the way asking for immediate relief, and everybody was sort of slow walked it. It was very frustrating, but we finally got the injunction lifted in that case, and then in a few others. And it was a good lesson in sort of thinking through, when you're an appellate lawyer, when you're in a state AG office, thinking through those kind of procedural barriers you're going to face. Because of course, when something as momentous as an abortion regulation, everybody who supports that law wants to have it go into effect as quickly as possible. So a lot of pressure kind of came to bear, just getting the decks cleared of that injunction and injunctions as to other abortion laws as well. So we spent a fair amount of time last July and August cleaning up as much as we could. Now, as it happened, our governor did call a special session of our legislature to come in and I think ostensibly it was about the redistricting of the congressional districts in the wake of the census. The census data was late and it was a very sort of drawn out process trying to get that done. And so the governor said, well, sure, we'll call a special session. I think it's for drawing new congressional districts. But of course he knew what was going to happen. There's no limit on what the legislature could consider. So they did the congressional districts, but they also enacted a broad abortion ban. The only exceptions are cases of rape or incest or where the life of the mother is at stake. So in any event, that law gets passed, no surprise, and we immediately get a challenge, as you might expect. What's left to do after Dobbs? State constitutions are left to do after Dobbs. And this was nothing new for us, candidly. We had been through a state constitutional challenge to an abortion regulation 20 years ago when I was in the office. And it was a challenge to a law that required in-person counseling when the informed consent process takes place. And this had to happen 18 hours before the abortion. And so the theory was, oh goodness, this requires 2 trips for the woman to the abortion clinic, and that's an undue burden. This so-called 2-trip requirement is an undue burden. And we battled in federal court, and we ultimately succeeded. And then we got sued in state court under a state constitutional theory, under the theory that Article 1, Section 1 of the Indiana Constitution, which speaks in terms of the right to life, liberty, and pursuit of happiness, a so-called Lockean proviso, a natural law kind of theoretical approach to constitutional law, that text secured the right to abortion. This is 20 years ago, okay? Well, we fought hard on that. We get to the Indiana Supreme Court, and I thought we had a really good shot then. It's a conservative state. It has produced lots of Republican governors. It's produced a lot of fairly conservative originalist justices over the years. And I thought, okay, we'll get this now. We'll get a good, solid decision that there's no right to abortion in Indiana. And then when and if Roe and Casey ever get overturned, we'll be in great shape. Well, what did this court do in the name of judicial minimalism? It decided it would assume that there's a right to abortion under the Indiana Constitution. Not going to decide, we're just going to assume. This is in 2005, I think, by the time they got around to it. We're going to assume there's a right to abortion under the Indiana Constitution. Well, how can they get away with that? Because ultimately it didn't matter, they said, because even if there's a right to abortion under the Indiana Constitution, Indiana wins. How do you know if you don't know what the right to abortion is or kind of what its parameters are? Well, gosh, they said, if there's a right to abortion under the Indiana Constitution, really, we're talking about the same right as the federal Constitution. You know, we're usually big advocates of independent state constitutionalism, but looking at abortion, what could the standard possibly be besides this undue burden standard? And the state's already won in federal court under the Casey undue burden standard, so ta-da, they win under the Indiana Constitution. Okay. Well, if we ever have to revisit the right to abortion, we have a clean, ability to do that. We're not making that decision today. Oh my God, it was just absolutely maddening, right? How in the world can you come up with a standard when you assume a right and you don't do any of the hard work that it takes to figure out whether a right exists and what its parameters are? Well, we got the victory. Life goes on, but now we're back in the Indiana courts having to answer that fundamental question. Is there a right to abortion? Now, we have excellent case law in Indiana going back decades, 50, 60, 70 years, that speaks in terms of having an originalist philosophy in terms of the approach of interpreting our Constitution. Lots of case law and rejecting living constitutionalism, really kind of squarely stated principles in that regard, which is terrific, right? Because not every state constitution has a court that would have said those things over the years. And that puts us in a really good position just from the get-go. We think we don't have to really do too much with living constitutionalism because that would really be something for this court now to sort of reject that broad approach, especially knowing the justices that we have on our state Supreme Court, which again, are all Republican appointees, they tend to be pretty conservative. We felt pretty good about that because historically, we have one of the best records that you could imagine for defending a ban on abortion. Our Constitution was adopted in 1851, and the Indiana legislature, as this is even noted in the Dobbs opinion, banned abortion outright. It had been, forget common law for a minute, just set that aside, a different story, forget common law for a second. The Indiana legislature banned abortion in 1835. And then we have the Constitutional Convention in 1850. No one's talking about abortion. No one's mentioning abortion. No one's saying, "Oh my God, we got to, come up. This is a great opportunity to create a right to abortion." Of course not. Nobody's talking about that in 1850. It gets ratified in 1851. In 1852, the legislature enacts another ban on abortion, just sort of updating the language and whatnot, clear as can be. They do it again in the 1860s, a couple more times into the 20th century, all the way up to Roe. It is against law in Indiana to have an abortion. And there's no mention of quickening, right? That's the argument you hear so often from those who say, well, those bans didn't really affect the first trimester abortions because they only took hold after the woman could feel movement in the womb. No, there was no mention of quickening, and it was, clear as can be. There's really just no historical foothold. So nonetheless, we face the constitutional challenge in the Indiana courts, and we draw a judge in a lawsuit filed in Bloomington, Indiana, mind you, which is, this is where IU is. It's a fairly liberal county, and so we drew a judge that I thought, well, okay, this isn't going to be too great because it's an elected judge in Bloomington, and who knows how that's going to go. Oh, but then that judge disqualified himself because, well, I'm not even sure why. He disqualified himself. It doesn't really matter why. And they have a system in that part of the state where they've got some kind of lottery that goes on with judges in neighboring counties to figure out who's going to get the cases when there's a recusal. And the judge that we drew was in a neighboring county, Owen County, which is a very rural county, a very conservative county, especially compared to Monroe County, where Bloomington is. And this is a Republican judge. And I'm thinking, yes, we got it. They thought they were so smart, filing their case in Bloomington, where all these liberals live, and they had to get a progressive judge. And boy, we really lucked out. And we went to court and we made our arguments, and she didn't really ask any questions. She asked one or two questions, but nothing really sort of telling about what her attitude was on all of this. And wouldn't you know it, she enjoined enforcement of the law right before it was set to go into effect. And we were just devastated. What on earth? We've told you about this idea that there were ban on abortion before, during, and after the constitutional adoption period. Nothing in the history of or cases in Indiana suggest right to abortion. And she says, well, sure, all of that's true. I can't argue with history here. But you know what? The people that debated, promulgated, drafted, ultimately adopted the Indiana Constitution in 1850, they had deficits. Go and imagine what those deficits were, right? 1850, who's doing the lawmaking in that era? It's white men. And in her view, that was a reason to ignore the history and the limited text that was relevant here, and to say that the Indiana Constitution really needs to be understood to provide a right to abortion, because we've come so far with respect to women's rights in the workplace, in society, just in general. How do you connect the dots on all of that? Now, she didn't really give much of a clue as to how she got from point A to point B on all of that. But it was just astounding, just an utter rejection of the significance of constitutional text, constitutional history, and the idea of constitutional law really to begin with. She just decided that there were some updates that needed to be made. So of course we appealed. I was very disappointed we did not get a stay of the injunction pending the appeal, but we have briefed and argued the case in the Indiana Supreme Court. We argued it in early January. I don't think, I don't know how it's going to come out. I feel good. It's a 5-member court. There are 3 of those 5 that regularly go to Federalist Society luncheons in Indianapolis. So hopefully they can be counted on. I don't to think clearly. The questions were good. I think pretty clearly that court is not interested in this. We can wipe out the entire Constitution because we don't like the makeup of the electorate in 1850. But who knows, right? So we're waiting on that decision. I'm hoping we'll get something by, I don't know, I'm guessing May. That's just a wild guess. I had a case in that court one time. This is a long time ago. It was an abortion-related case, believe it or not the one I mentioned earlier, but it had to do with abortion funding. And it sat in front of them for 2 years before they decided. No oral argument either, by the way. And it sat in front of them for 2 years. I thought they lost it. I don't think it's going to take that long, but we're looking at possibly, middle of the year sometime. Okay, so what else? On the heels of that challenge under the Indiana Article 1, Section 1 natural law parameter, we have a state RFRA case. Indiana has a Religious Freedom Restoration Act, actually enacted to great fanfare and controversy several years ago when Mike Pence was governor. And this is I think, attempt by the progressive to try to hoist the conservatives on their own petard. We're going to use RFRA to go after your new abortion law. They filed it in Indianapolis. They drew a judge who is, she's actually a good friend of mine, but progressive. And fair-minded, generally speaking, but probably just she has her way of looking at the world. And so we briefed on preliminary injunction whether the State Religious Freedom Restoration Act creates this opportunity for a right of accommodation on religious grounds for women who want abortion. And there were women of several different religious backgrounds who filed. There are a handful, I want to say maybe 3 Jewish women, an Episcopalian, a Muslim, and then somebody who was sort of a general spiritualist, I think. A pagan. Oh, there was a pagan as well. So we go in and it's pretty challenging in a representing the state to go in and ask tough questions about anybody's view of religion, right? You don't want to come off as heavy-handed. You want to be respectful. You want to be, celebratory of religious difference and religious insight and all of that. So we had to fight this battle in a way that didn't come across as big bad government trying to stomp on the religious rights of Hoosiers. So we really didn't question the sincerity of anyone's beliefs, which is one of the elements you have to demonstrate if you're a plaintiff in a RFRA case. Are you sincere? Is it a sincere religious practice that is at stake? We took some depositions to figure out what exactly they meant when they said that abortion was a religious practice that they were entitled to. And typically the answer was something like, look, well, my religious beliefs say, and I'm paraphrasing here, I'm sort of going to generalize a little bit. My religious beliefs say that if I get in a position where the pregnancy is a burden to me, maybe it's a health burden, but maybe not a health burden that's bad enough to trigger the exception for the life of the mother under the Indiana Constitution. But in that circumstance, my religion tells me I am to be the priority. My health is to be the priority. And it could be mental health, it could be physical health, whatever. I am to make that decision. Well, what do your spiritual leaders say about this? When does that happen? Is there an objective standard for that? Well, no. Spiritual leaders all say, it's just up to me. Okay, fine. We got it. At least we have the parameters figured out. And we made the argument to the court, look, really, none of these women, by the way, was pregnant. And I think all but two, maybe, wanted to avoid pregnancy. Were already taking steps to avoid pregnancy. They demonstrated their direct injury by saying they were taking even more steps to avoid pregnancy. And our point was, look, there's no need for a preliminary injunction here. There's nothing immediate about any of this. There's no real threat that this issue is going to come up. And by the way, all of the women said, I don't know whether I would want an abortion if I got pregnant. I might not. But I need to be able to decide in that moment. And our point was, look, you can't judge, you can't make that decision right now about whether there's a sincere religious practice that's going to be heavily burdened, or substantially burdened by this abortion law, because each of these women is saying, in the moment, they need to decide. Well, in the moment, the motivations might change, right? Who knows? There could be any number of motivations that go behind the abortion decision. And that's when you litigate it. If you're going to litigate it, that's when you have to litigate it. And by the way, of course, in our view, preserving embryonic life is a compelling interest that overrides all of this. So we should win, regardless. The judge disagreed with us, entered an injunction as to these individual plaintiffs, and we've now appealed that. So that's being briefed in the Indiana Court of Appeals. Probably will be argued sometime in April, would be my guess. And the Indiana Court of Appeals tends to be fairly quick, so I'm guessing, again, probably June, maybe, is when we'll get a decision. In the meantime, the plaintiffs in that case have moved for class certification. It's not enough that we have a handful of women who are not pregnant, don't intend to become pregnant, who are arguing about their abortion rights, but now they wanted to have this preliminary injunction applied to an entire class of women who don't need to come before the court and have anything specifically adjudicated. The class definition is pretty broad, as you might imagine, and it's effectively any woman whose RFRA rights would be violated by the abortion law. Well, that's our view, not a proper way to define a class. So we're fighting over class certification now in the trial court, and there's going to be a hearing on that in April, and we'll see how that goes. Scott's not here yet, is he?
He should be here in the next 5 to 10.
Great, 5 to 10. That's all I need. All right. So I want to update you on a couple of other abortion-related litigation matters going on around the country, where Indiana is involved in the amicus capacity. There are two cases in state Supreme Courts challenging laws that existed, that were on the books before Dobbs. Couldn't be enforced, but in the wake of Dobbs, they can be, at least under federal constitutional principles. And in these cases, the trial judges ruled, one's in Florida, one's in Iowa, I don't know if I mentioned that. I'm sorry, Georgia and Iowa. In these cases, the trial judges ruled that, well, these laws were enacted when Roe and Casey were the law of the land. And because Roe and Casey were the law of the land, these laws were void ab initio, when enacted, they were void right out of the box. And so they're void now. Doesn't matter that Dobbs has overturned Roe and Casey. These laws were void when enacted, so they can't be enforced. Which is really, really something. It's really an unusually broad evaluation of judicial power, especially federal judicial power, which is effectively what they're talking about, right? You're talking about federal decisions on federal rights. And so Georgia and Iowa both appealed those to their state Supreme Courts, and we've filed amicus briefs supporting those positions, talking about how really, no, we got it all wrong and we were talking about this earlier, a few of us, this rid of erasure fallacy, right? This Jonathan Mitchell idea, which you don't have when you have an injunction from a federal court on a state law. You're not voiding the law. All you're doing is having a decree that an official can't carry out enforcement of the law. It runs to that official, and sure, in the wake of a case decision like Dobbs, you might go back like we did and get the injunction lifted if it's no longer justified by law. But that doesn't say anything about the statute itself. So in a state, for example, like Indiana, where these abortion laws, for the most part, are enforced by county prosecutors, well, the county prosecutors who were never enjoined from enforcing the law, they're perfectly free. The only barrier to their enforcement of these laws before Dobbs was if they would try to do it, the case would be dismissed. So we're making all of these arguments that we really have a skewed concept of what it means for the judiciary to review state laws under the Constitution and what that impact is. So we're hopeful we'll get favorable decisions from the Georgia and Iowa Supreme Courts. The last one I'll tell you about, unless Scott's not here, and then I'll try to keep going, is a case involving a statute known as EMTALA, and I'm going to butcher the acronym here, Emergency Medical Treatment or something, I don't know. Anyways, this is the law that applies to hospitals that are Medicare providers, and it requires hospitals that are Medicare providers to provide emergency care for people who come in, regardless of ability to pay. So they can't just ditch patients who don't have insurance or don't have cash and throw them out or send them to a different hospital. They have to treat. That's just one of the conditions of being a Medicare provider. And the federal government has taken the position that EMTALA requires these hospitals and the physicians who practice there, who are Medicare providers, to perform abortions on women who come in and are demanding emergent abortion care. Now, how one defines that is, another matter. It's, I'm sure that even if we were to agree on the terms, which we don't, that this generally could happen, that we would have a fight over what it means to have to demand an emergency abortion. But the theory is that there's a preemption, that this statute, which is triggered by, well, ladies and gentlemen, the abortion heavyweight champion of the world, Scott Stewart. Sorry, man. Great to see you. I'll be done. Just give me a second. Just give me a second. So the theory here is that you have federal grant recipients, federal contractors, essentially, who accept federal money on the condition of abiding by federal grant terms, buying their way out, or being bought out of, perhaps is the better way to put it, state law restrictions. What concept of federalism permits the federal government to pay people to violate state law? It's a really extraordinary theory of preemption. And so this is a case that's going on in Idaho. There was one that started in Texas that seems to have petered out. There's one in Idaho where we filed an amicus brief at the trial court stage, talking about how, well, goodness, this is not how preemption works. This is not how spending clause statutes work. And if they did work this way, that would be a real problem under the 10th Amendment and under, drumroll please, the Republican form of government clause, because you can't have individual grant recipients making unilateral decisions to slip out from under the restrictions of state law. So that's still in the district court. It's an interesting case. It's an interesting battle, and I'm optimistic ultimately that Idaho will prevail. But it's going to be a long road. But So plenty of action out there for us to undertake even in the wake of Dobbs. And I'll where'd Scott go? Okay, good. I'll let him take over from there, Scott. I saved all your thunder for you on Dobbs. I didn't get into that at all, so I'll let you tell them about Dobbs, and then maybe we'll take questions after that.
Awesome.
All right.
Hey folks, sorry I'm late. I had a little bit of unfortunate luck with flights, but sometimes that's how it goes. I guess, so you covered a lot of law.
Yeah, a couple things.
Like the law. Everybody knows Dobbs already to some extent. You know the arguments. They've been kind of out there, the opinions out there. I know it's long, but folks here have surely read the opinion or kind of gathered it. I think it's kind of useful in this kind of a case to. This is a special case. Dobbs is a special case. It's not like other cases, and it's worth, I think, reflecting on why that is. And I want to focus on something that I think that, putting the law aside, there are kind of enduring aspects of this case that I think are kind of important and telling. And I know that there are people in this room, one way or another, who want to work on cases that have high impact on things that you think believe in that are really important. So I want to kind of talk about that for a few minutes. Recognize that we don't have a ton of time, and leave a little bit for questions, and I'll happily hang out afterward. And kind of like the short bottom line that I want to talk about is really character. As lawyers and as law students, we tend to focus on knowledge, on like what the words say on the page of the statute book or of the case book. We focus on lawyerly skill. Those are important. You need them. You especially need them in a very high stakes case like this, or high stakes matters like abortion cases, or really anything that matters. But if you go into trying to do high impact work, you realize very fast that the important questions, the hard questions, the things that, like the difficult questions in these cases are not what is the law or what's the legal argument. The difficult and important questions are the character questions. Can you take the heat from taking a hard position? Do you do the right thing when it's hard? Will you stand for the principled position no matter what the cost and despite the risk? And what's interesting in a case like this, if you're involved in it in any way, whether it's litigating for a party, whatever it is, sitting on the bench, certainly in a case like this, you learn the answer to those questions for yourself about who you are, and that's for better or for worse. So I just kind of want to hit 3 points on that. One, kind of like looking back a little. Two, looking at the decision itself just briefly, and kind of what it means. And last, kind of just looking forward. And looking back is, it's hard to remember now, but when this case was granted a little over a year and a half ago, the prevailing view was that the court did not take the case to overrule Roe versus Wade and Planned Parenthood versus Casey. The kind of consensus view that I encountered with folks is that the court took this case to maybe chip back, or to sort of rein in, or to clarify, or kind of redefine. Some version of that was kind of what I heard. And as I was kind of thinking through, how should we approach this case? Should we take a shot? Because the fundamental fork in the road decision in this case that determines so much is, what do you ask the court to do? Do you ask the court to overrule Roe versus Wade and Planned Parenthood versus Casey? Or do you ask for something smaller? Do you just say, just uphold this 15-week restriction that Mississippi has adopted? And that question, there are elements of judgment, there are elements of skill there, but to a big extent, answering that question is a character question. Very, very smart people, what I'll describe as the very, people who I really respect, people who've argued many, many dozens of cases, the consensus view among what I describe as the elite DC Supreme Court litigator group was, the court will not overrule Roe and Casey. Like, that will never happen. Do not argue for it. If you argue for it, it will be an unmitigated disaster, and you could lose. Like, do not do that. Like, that was the consensus view of people I encountered. And it's very like, that like has a lot of compelling things to it, because the reality is that if you're a baseball player, you can't always go for a grand slam. The runners aren't always there, the pitch isn't always there. You got to settle for less sometimes. But at the same time, you don't get that many shots. It's been 30 years since Casey. Like, this was the first time in a long time that the kind of Roe, Casey, the fundamental questions were teed up. You don't know if there's going to be another shot. A lot of people said, hey, what you should do is kind of chip away by getting your law upheld, and then like the next case.
The Indiana case was the one I was hoping for, but it's all right.
30 years for the Indiana case. You just have to, in Planned Parenthood versus Casey itself, Pennsylvania's lead argument was not overrule Roe. Their lead argument was adopt the undue burden standard. On page 104 of their 114-page brief, that's when they started arguing, in the alternative, overrule Roe versus Wade. So you look at that, you appreciate it, and you kind of but ultimately, you have to make a decision, and reading a stack of cases is not going to answer that for you. And to a very, very big measure, I think it's a character question in a lot of ways, in addition to kind of legal skill and judgment. And something that, just to give you an insight on why we in Mississippi kind of answered that question the way we did was, something we kind of knew is that there was magic in boldness, and when you stand up for the right thing, when you do it in the right way, that can change things beyond the comprehension of the intellect, and it can just really change the course of reality. So again, I emphasize kind of a part that I think is underemphasized among really, really, really good lawyers who I have tremendous respect for, and who I think would be right 99 out of 100 times in a Supreme Court case, kind of judgment context. But that's one thing. Next thing, just to talk a little bit about the decision itself, not the particulars. It is a phenomenal decision. The reasoning is just right. But the thing that I want to emphasize about why I think this really is the key reason why it's a great decision in kind of a bigger way is that it's a great decision because it was hard. The court was under tremendous pressure, and we all saw all the horrible things that were happening, around this time last year. The things that happened with the court as an institution. What I'm sorry to say, and we all saw it, what different justices saw, over time, and just that whole thing, the reaction that you can't condemn it strongly enough, basically. But it's those features are part of what makes Dobbs such a great decision, because easy things aren't great, and everything that matters in life is hard. All of the great things in our country, in our history, the struggle for civil rights, the battle for independence, winning the Civil War, all those things were exceptionally costly, difficult, and hard, and that's why they're so great. And the great thing about Dobbs is that the court didn't just do the right thing, but it did the right thing when the right thing was really hard, and where just looking forward, I've been at a fair number of law schools in the last year, and there are a lot of different kind of, I know the kind of the mood at law schools and the kind of different, there are both good and bad things going at law schools right now. There are a lot of interesting intellectual debates, a lot of engagement, a lot of excitement about kind of matters of constitutional theory, how to get the law right, how to get decisions right, how to select the right people to make decisions in a judicial context. There are also very hard things, just challenges. It's I think better here at this school than many of the other schools I visit, but relationships with faculty, just getting along, if you're of a certain point of view, is very, very hard at some schools. And for the good or the bad, whatever is going on, what I will say is, I'll come back to the character issues will really decide how well those kinds of things go for you, and they transcend all of those things. I think it's great to really drill down on what is the right way to view the Constitution, what is the right theory of constitutional interpretation, but there are limits to any theory. No theory can solve the problems of willfulness, of weakness, and frankly just human frailty. Just error. Very well-meaning judges make mistakes. From time to time, you'll see, my old boss say, hey, I made an error in this past case, and it wasn't because, he wasn't trying hard in that past case. It wasn't that he didn't do anything. But, some people just make errors, and I think fundamentally, theory will get you only so far, and ultimately, it will come down to, do you have the character to do the right thing, make the right decision, and stick by what you know to be right. So, just kind of I think whether you're a law student, a lawyer, a judge, The character decisions will be the biggest ones, especially if you want to do really high impact litigation, because it comes down to the character issues rather than just the legal skills. So anyway, not a lot of law in there, but there it is. So with that, any more, or should we just go to questions?
That's a mic drop moment for me.
Good stuff. All right.
Thank you both. Any questions?
So, Mr. Fisher, your story about the judge in Owen County, like, really got me like, there's so much bad legal reasoning out there, and like maybe this reasoning was motivated, but I think there's also just like legitimately bad legal, like, how are we in a situation where there's like, people are like trying to find jobs and struggling to find jobs coming out of law school, but also there's just like so much bad lawyering happening. Like, shouldn't the market have been taken over by good lawyers at this point?
Yeah. Now, look, I am saddened by that decision. The judge in that case, I don't know her well. I've gotten to know her through my end of court a little bit. She's a delightful woman. She seems very smart, very reasonable. I'm just flabbergasted by the decision that she made. But you'll figure this out very quickly when you get into the profession. There are a lot of bad lawyers out there, and it just is, it's just always been that way. And especially, many of you, I'm sure, will go on to judicial clerkships, and those are terrific opportunities. And there are terrific opportunities to see the good, the bad, and the ugly among the lawyers that are filing briefs and coming in and making arguments. And you wonder, did they never have any of the kind of instruction that you had in law school? What were they sick that day? What happened? But that's nothing new. And I think the hope is that by the time the cases get to the final decision makers, the system has weeded out enough of the folks who maybe are underperformers that we've got reasonably strong intellects making the final decisions. And I don't, I would not at all demean the intellect of the judge who decided our case. I genuinely, I think she's very sincere, and she's not being willful. She sincerely looks at the Constitution a very different way, and the rule of the Constitution, and that's the lot we draw.
Mr. Randy.
Thank you both for coming. You spoke about the desire after Dobbs to get the laws implemented as quickly as possible. In my own state, Utah, there's been a long judicial battle about Utah's trigger law as well. One of the things that's come out of that is a new initiative by the legislature to remove a number of partisan safeguards on the judicial nomination process. I'm wondering if either of you can speak to whether or not this desire born out of exuberance to finally achieve a goal that has been worked for so long can lead to possibly more negative effects than taking a little more time.
Scott, you want to go?
That's a really good question. If you ever work in a hard public service job, so I worked at DOJ for 4 years, and I was in a political position. I saw a lot of people sign up for these hard political positions. And what you realize very quickly in life is that, in those positions, I should say, is that there are a lot of people with skills, and there are a lot of people with commitment to principle, true believers. And there's not enough overlap between those two groups. There's very little overlap. And I don't know the particulars of whatever situation. I'll just speak kind of broadly. But you see very often, I think, unfortunately, people not using good enough judgment in whatever important area it is. They rush too fast. They're like, oh, this policy has, and I'm actually thinking about just things I saw, in my time in the federal government, not even speaking to. They're like, I understand why, a lot of trigger laws were really immediate. You kind of expected things to happen. But there is this difficulty you see where, people mean well, but they make misjudgments. They don't realize, hey, this is going to lead to litigation. Maybe it's worth getting it ready so it withstands litigation, so that we actually can take a step forward rather than 3 steps backward. And what you often end up seeing, unfortunately, I'm sorry to say, I look at the first year of the Trump administration as an example. but a lot of people who's like, no, we have to have this policy in place 11 seconds from now, and then you're 2 years into the administration, and all you have is a bunch of injunctions that not only knock down every policy you wanted to do, but actually like set you off because you're behind the 8 ball on every other effort to do it. So, again, speaking kind of broader, kind of a factor, some things are truly more immediate than others, but that is a reality that I have seen over time. That is an unfortunate dynamic, and you just have to do the best you absolutely can if you're somebody who, and this is why I say, like, develop the skills, develop the legal skills, develop character, judgment, all of those things, because the world is desperate for people who unite those skills.
Yeah, just to add, I think trying to come up with a selection plan for judges based on a particular dynamic in doctrine is a really bad way to go about it. You really need to just return to first principles and think about what is it that matters when you're selecting judges. And different people will come to different conclusions. Some people say it's got to be, we got to maximize accountability. Very defensible way to look at it. Other people say, no, we have to maximize independence. Okay, another defensible way. How do you is there a way to make those two fit together so that you've got some of each? Another defensible way to look at it. And that's the way I think to think about it. And that's, I think, probably the more responsible way to think about judge picking.
Matt?
Mr. Stewart, in your experience, you can talk about yourself, you can talk about what you've observed in other lawyers. What does it entail for a lawyer to cultivate the moral character that it requires to do this sort of litigation?
Yeah, learn how to look somebody in the eye and tell them the truth when it's uncomfortable, and not have any emotion behind it, and just be honest and just say, look, you're wrong about this, I don't agree with you. Learn how to be the one person in a room of 12 who says, this is a bad idea, you guys may end up going to do it, but like, you should not do this. Like, this is gonna go wrong, and like, don't worry about or don't give any weight to the fact that like, everybody's gonna look at you like you're not on the team, because I've been in a lot of rooms like that where a lot of people knew something was a bad idea and nobody wanted to say it because they wanted to look like they were a true believer and on the team. Those are two, but like really it's like little things in the way like you are doing today. Like the key thing about it is like, you don't want to wait. It's if you like end up with a Dobbs or something like that, or a big abortion case, or a big this case or that, it's too late if you haven't already started developing. So wherever you are in life now, just like be honest and fair with people. Don't talk about people behind their back. Say what you believe. Learn to disagree without being disagreeable. Don't sell people out to get ahead. Just really simple, honest. What would Justice Thomas do? Kind of thing. Like, that's a pretty, I mean, really, it's like Justice Thomas is this fantastic man in justice, not because he has some like secret, book about like the best constitutional theory. It's just he's a man who's been committed to doing the right thing for a very long time and does his level best to get every single case and every single thing right. The last thing I'll mention is people, as you kind of get out of law school, like I kind of thought when I was in law school that like all these people who were gunners would always be kind of like going for the fences and doing great things, and people very quickly start to drop off, and you learn that what happens is that like not many people really are equipped to deal with adversity, but learning to deal with the ups and downs of life and not get too wound up and not get bitter about like this bad thing or that, just like keep going, regroup, don't be bitter at people for stabbing you in the back or doing things, just like still be an honest and fair person. Like that is what character is. And it sets you up and puts you on a path that makes your life like astronomically better, like beyond your possible imagining. And most people don't take that approach, but it is, you can have a majestic life if you do that.
The worst thing in this profession, I think, this was certainly true, much more true for me when I was first starting out, and it got better over time. But the worst thing in this profession is feeling like you're just constantly reacting, that you don't have, you're not sure where things fit in, and all you know is, in this moment, do I like this thing or not? Not sort of the broader, more informed decision. And I mentioned first principles a minute ago, I'll come back to it again. It's so critical to grapple with those while you're here in law school and just elsewhere in life, and know your mind. When you know your mind, it doesn't matter, which direction is buffeting you. You've got that steady course, and I think, that's critical to doing well in kind of the high impact cases.
We have time for 2 more. Karan.
Hi. One part of the brief for dogs, as well as the decision that I wasn't sold by, was speaking to the reliance interest. Like, data suggests that the nature of female participation in the workplace, a lot of these things have changed in the face of Roe, and I feel like that was not adequately addressed by the majority opinion. I'm wondering if you could speak to that.
Yeah. So I guess a couple observations. One is that even as abortion rates and ratios have kind of plummeted in the years since Casey, women's success, participation, really every metric has continued to skyrocket. It's very hard to pin women's success to abortion, and there are also a lot of bad consequences that are more clearly associated with the rise of abortion, about just disintegration of families, the problems that end up falling more on women than on men. One of the briefs that's really good, if you weren't, one of the great things about these cases is the amicus briefs. Yeah. They can give 30 pages to what we can't quite give that many pages to. There's a brief it's called the brief of 241 women scholars and professionals that I think kind of goes into those things, does it extremely effectively. Another one is one by women legislators about kind of the rise of women's success and representation in legislative bodies, both federally and at state levels, and how that the effects that those have had tangibly on success outcomes, those kinds of things. So there are a few thoughts there. I know that's not a full answer, but those are certainly things that we try to bring across, loop to, cite in our brief, and do it as best possible. But as with a lot of things, there's a very big, rich debate there.
Thank you both for your time today. I do have a substantive question, SG Fisher, about something you said, and then any thoughts as well, SG Stewart. The RFRA cases, it does seem to be kind of a claim on the rise that for at least some women, not being able to access abortion is some kind of violation of their religious beliefs. And I know in the case that you discussed, it's not really required, but let's just say that a bunch of women form some religion and have their creedal documents, and it is a requirement that they're able to access abortion. And if not, there's these great religious consequences. Does RFRA require that a court respect that religious belief? And if not, do we have to impose sincerity requirements or define what a religion is? Because those are things that it seems like courts haven't really been willing to do so far.
And courts, for very good reasons, are very reluctant to get into the questioning the core of somebody's professed religious belief. It's not something that works with our tradition very well. That said, the sincerity component of a RFRA claim is a real thing. I had a case a few years ago involving the first church of cannabis.
Not the last church.
Not the last. Not the last. But certainly claiming to be the first. And they did all of the superficial stuff right. They had somebody that donated a building to them to be their church. They had a gift shop where they sold little, well, I don't know what they sold, but it was apparently not illegal in itself, perhaps used to facilitate. Anyway, they said that they were going to smoke. The whole point, of course, was to smoke cannabis as their sacrament. They said they were going to do it. The police showed up, and then they were great at sort of the whole, you're trying on our religion, and they really did a very nice job of all of this. The leader was a really charismatic guy and very thoughtful guy. Many other issues there, but he did a very good job of sort of thinking through and having something to talk about. And yet, I was never convinced of his sincerity. Never, not once. We presented a case for defending the state criminalization of marijuana that focused, part one, on his sincerity, because we wanted to make sure that the judge and the courts saw those weaknesses. We did not for a minute think that would be where the decision turned. we came even stronger on our compelling interest in prohibiting marijuana consumption. And I think that that's where we're going to have to win on abortion. And candidly, it's more challenging in the abortion context to question sincerity because of all of the cultural things that go into what it takes to be a woman who comes into court and says abortion is important to me. It's very difficult to look like the good guy if you're going after that plaintiff. So where do we win? We win on compelling interest, and if nowhere else, right? Now, the decision that we got from our state trial court on this, again, just a different way of looking at the law. Some shades of those Georgia and Iowa cases that I was mentioning. We said, look, we have a compelling interest in protecting fetal life, no matter the reason for the abortion. We have a case, an Indiana Supreme Court case from 1972, like right before Roe, that said the state has a compelling interest in the development of the fetus at all stages. Like, ta-da! There it is. State Supreme Court controls. She says, no, it doesn't, because Roe. Well, but Dobbs. Dobbs did not specifically say that states have a compelling interest in protecting fetal life at all stages. What, are you kidding me? Well, so there was this idea that somehow there is this vestige of Roe, at least in her mind, that continues to limit what states can claim to be compelling versus legitimate. Okay, all of that's probably more detailed than you wanted, but the point is, I think ultimately that's where you have to plan to win those cases. You set up that win by calling into question some of the other pieces, whether it's sincerity or the burden that's being claimed. There are pieces of those arguments you can make that call into the court's mind some questions, but ultimately shoves them towards, okay, the state has to win on compelling interest. So that's my thought about it.
Thank you both so much.